Welcome to literary and jury charge practice. Let's start out with some jury charge. Ready? Here we go. Some of the factors that you must consider are 1. The age of the defendant, 2. The defendant's education or lack of education, 3. The defendant's mental ability or capacity, 4. The defendant's IQ or intelligence, 5. The defendant's background and environment, 6. The place and length of detention, 7. The nature of the questioning, and 8. The advice or lack thereof to the defendant of his constitutional rights, including but not limited to the right to remain silent, that any statement could be used against him in a court of law, the right to have a lawyer present, that if he could not afford a lawyer would be appointed to represent him without any cost, and that he could stop making a statement at any time. You must carefully consider all of the surrounding circumstances before you give any weight to an alleged statement. The state has the burden of proving beyond a reasonable doubt that the alleged statement was voluntary. If you determine it was, you may give the statement any further consideration that you deem proper. You must decide what weight, if any, should be given to the alleged statement. If you determine the alleged statement was not the free and voluntary statement of the defendant, you should not consider the statement at all. The defendant is charged with murder. The state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be expressed or inferred. These terms, express and inferred, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist, that is, either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will toward another, or when the person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person or any other acts of preparation going to show that the deed was within the defendant's mind would be express malice. Malice may be inferred from conduct showing a total disregard for human life. If you determine that the state has not proven murder beyond a reasonable doubt, you should then consider whether the state has proved beyond a reasonable doubt that the defendant is guilty of the lesser included offense of voluntary manslaughter. Of course, you cannot find the defendant guilty of any offense unless you are convinced of guilt beyond a reasonable doubt. To prove voluntary manslaughter, the state must prove beyond a reasonable doubt that the defendant took the life of another in the sudden heat of passion based on sufficient legal provocation. Both heat of passion and sufficient legal provocation must be present at the time of the killing to constitute voluntary manslaughter. Sudden heat of passion may for a time affect a person's self-control and temporarily disturb a person's reason. The sudden heat of passion must be the type that would make an ordinary person unable to coolly reflect on his actions and would produce an uncontrollable impulse to do violence. Sufficient legal provocation must be the type that would make a person of ordinary reason and caution become enraged and to lose control temporarily. The provocation needed for voluntary manslaughter must come from some act of or related to the victim. Words alone, however vulgar or insulting, are not enough to be legal provocation. Where death is caused by the use of a deadly weapon, the words must be accompanied by some overt threatening act which could have produced the heat of passion. The exercise of a legal right, no matter how offensive it is to another, is never sufficient legal provocation for voluntary manslaughter. If the heat of passion had cooled, or if there was enough time between the provocation, if any, and the killing for the passion of a reasonable person to cool, the killing would not be voluntary manslaughter. In deciding whether a reasonable person would have had enough time to cool off, you should consider all the circumstances surrounding the killing. You may consider the nature of the provocation, if any, the defendant's mental and physical state, and the circumstances and relationships between the parties. The defendant has presented evidence of his good reputation and character to show that it would be inconsistent with the defendant committing the crime. The weight you give to that testimony, like all other testimony in the case, is for you to decide in your good judgment. You may consider testimony of the defendant's good character along with all the other evidence in deciding whether or not the defendant is guilty or not guilty. A police officer may use reasonable force in carrying out a lawful arrest. Whether the force used was reasonable depends on the facts of the case and is a question for you to decide. You must look at the circumstances that appeared to the officer at the time that the deadly force was used and decide whether an ordinary and reasonable person acting with the same knowledge and in the same situation as the officer would have believed that the force used was necessary. If you find that the degree of force used by the defendant was reasonable, you must find the defendant not guilty. The defendant has raised the defense of self-defense. Self-defense is a complete defense, and if it is established, you must find the defendant not guilty. The state has the burden of disproving self-defense by proof beyond a reasonable doubt. If you have a reasonable doubt of the defendant's guilt after considering all the evidence, including the evidence of self-defense, then you must find the defendant not guilty. On the other hand, if you have no reasonable doubt of the defendant's guilt after considering all the evidence, including the evidence of self-defense, then you must find the defendant guilty. The following elements are required to establish self-defense. First, the defendant must be without fault in bringing on the difficulty. If the defendant's conduct was the type which was reasonably calculated to and did provoke a deadly assault, the defendant would be at fault in bringing on the difficulty and would not be entitled to an acquittal based on self-defense. The second element of self-defense is that the defendant was actually in imminent danger of death or serious bodily injury, or that the defendant actually believed he was in imminent danger of death or serious bodily injury. If the defendant was actually in imminent danger, it must be shown that the circumstances would have warranted a person of ordinary firmness and courage to strike the fatal blow to prevent death or serious bodily injury. If the defendant believed he was in imminent danger of death or serious bodily injury, it must be shown that a reasonably prudent person of ordinary firmness and courage would have had the same belief. In deciding whether the defendant actually was or believed he was in imminent danger of death or serious bodily injury, you should consider all the facts and circumstances surrounding the crime, including the physical condition and characteristics of the defendant and the victim. The defendant does not have to show that he was actually in danger. It is enough if the defendant believed he was in imminent danger, and a reasonably prudent person of ordinary firmness and courage would have had the same belief. The defendant has the right to act on appearances, even though the defendant's beliefs may have been mistaken. It is for you to decide whether the defendant's fear of immediate danger of death or serious bodily injury was reasonable and would have been felt by an ordinary person in the same situation. All right, we'll stop there. And try some literary practice. All right, get back to the jury charge. But now for some literary. Ready? Here we go. This is called The Millionaire. Here we go. After almost 2 years of despondency following his wife's death, Herod was happy again. The 81-year-old from Placentia had reconnected with a girlfriend from his youth nearly 60 years later. Herod and Fontal Heater were married at the Fullerton Courthouse in 2009. His new wife then returned to her Missouri home to collect her belongings and prepare for the move to California. On July 27, about a month after their wedding, Herod spent the day with his son-in-law getting the house fixed up in preparation for Fontel's arrival. In the afternoon, the son-in-law drove off to Home Depot to buy a new toilet tank for the upstairs bathroom. When he returned, he found the maid, whom Herod had called earlier in the day to clean up the house, waiting outside. The front door was locked. Herod's keys and wallet were gone, but he didn't take his glasses or his car. Bob Herod was never seen again. The Placentia police eventually approached the case as a homicide, but could not find a body or evidence of a crime scene in the house. Detectives conducted an intensive investigation, including examining video surveillance and polygraphing family members and those close to Herod, who was worth about $5 million, though he lived modestly and drove an old Toyota. The investigation stalled, and Herod's daughters hired a private investigator, posted flyers, and offered a $50,000 reward. In 2013, Placentia police eventually turned to renowned investigator Larry Montgomery, dubbed the Evidence Whisperer by Dateline NBC, which featured one of his cases. Montgomery, who retired from the Orange County District Attorney's Office and is now working part-time for the department, has put more than 20 killers in prison and cleared some of the county's most notorious cold cases. The Herod investigation, he says, is ongoing. He has uncovered a few new leads, but declines to elaborate. Placentia police did everything they could, says Montgomery, who has a methodical manner and an impressive recall when discussing the details of decades-old cases. They turned to me because I've handled a few cases for them in the past. They trusted me, and I look at things a little differently. Herod's finances piqued the interest of investigators. Shortly after his wife's death and before he reconnected with Fontel, he began spending time with a 44-year-old woman who was his barber. He loaned her $86,000 over a period of 9 months, but after he married Fontel, he demanded to be paid back. Detectives found notes at Herod's house indicating he intended to put his new wife's name on some assets, including properties. A week and a half after he disappeared, 2 of Herod's daughters filed a petition for conservatorship in order to obtain control over their father's assets. They intended to use some of the money to put up the reward pay bills and maintain the house. Fontel contested the action, moved into Herod's house, and changed the locks. She was forced to move when Herod's family inherited the property in 2014. In California, a person can be declared dead if they have been missing for 5 years. While it's nice to have a body in a case like this, it's not a necessity, Montgomery says. You can always bring witnesses into court, show that the person was responsible, and that there's no way he'd simply disappear unless he was dead. Yes, this is a missing persons case, but I'd call it a very suspicious one. Right, back to some jury charge practice. Looks like we may finish this one up. We'll see. Ready? Here we go. The final element of self-defense is that the defendant had no other probable way to avoid the danger of death or serious bodily injury than to act as the defendant did in this particular instance. A person cannot be required to make an exact calculation as to the degree or amount of force which may be needed to avoid death or serious bodily harm. Therefore, in self-defense, the defendant has the right to use the force needed to avoid death or serious bodily harm. The force used in self-defense does not have to be limited to the degree or amount of force used by the victim. The defendant has the right to use so much force as appeared to be necessary for complete self-protection, and which a person of ordinary reason and firmness would have believed to be needed to prevent death or serious bodily harm. If the defendant is justified in defending himself and in firing the first shot, then the defendant is also justified in continuing to shoot until it is apparent that the danger of death or serious bodily injury has completely ended. Mr. Foreman and members of the jury, I am required to charge you the law as I have done through these instructions now being given to help guide you to a just and lawful verdict. Whether some of these instructions will apply will depend upon what you find to be the facts. The fact that I have instructed you on various subjects on this case must not be taken as indicating an opinion of this court as to what you should find to be the fact or what your verdict should be. Now you have been chosen and sworn to give the parties in this case a fair and impartial trial. When you have done so, you will have complied with your oath, and no one will have a right to criticize your verdict. You must not be influenced by opinions or expressions of opinion you may have heard outside of the courtroom, but rather should base your verdict solely on the testimony of the sworn witnesses who took the stand, the exhibits received into evidence, and the law which I have stated. You should not be swayed by caprice, passion, prejudice, or improper sympathy for or against anyone in this case. Remember, you have no friends to reward or enemies to punish, and all parties are entitled to a fair and impartial trial. It is your duty as jurors to consult with one another and to deliberate in an effort to reach an agreement. Each of you must decide this case for yourself, but only after impartial consideration of all the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if you become convinced it is erroneous. However, do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. As I stated earlier, you are judges of the facts. Your verdict must represent the considered judgment of each juror. In other words, your verdict must be unanimous. Now, you may have noticed that I have read these instructions. I do so to give you the law as accurately as possible. I will give you a copy of these instructions to have in the jury room. You may refer to these instructions to assist you in your deliberations. You must consider the instructions as a whole and may not follow some and ignore others. Mr. Foreman, it will be your duty to preside over the deliberations of the jury. If during your deliberations you should desire to communicate with the court, please reduce your message or question to writing signed by your foreperson and pass the note to the bailiff, who will bring it to my attention. I will then respond as promptly as possible, either in writing or by having you return to the courtroom. Now you have heard the evidence and you have heard the law. Whatever your verdict, Mr. Foreman, you will indicate it on the verdict form and then sign and date your verdict. Remember that although the foreperson is the only juror who writes the verdict, it is not his alone. The verdict has to be unanimous. Mr. Foreman, you are not authorized to write the verdict until all of you have agreed on the verdict. Right. Let's see what we have here for a little literary practice. All right, this is called Honey, I'm Buying a Home. Here we go. Do you see yourself starting a family in the next few years? My real estate agent asked, one hand on her hip. We stood on the sidewalk, having just toured a condo in Costa Mesa. She was asking for practical reasons, trying to finally nail down whether we should be looking at 1 or 2 bedroom places and if she should narrow it by school district. I stood there wide-eyed, suddenly sweating. I was 25 and fulfilling a lifelong dream of buying my own home in Orange County. I thought the process would be quick. I'd lived in Orange County all my life and know the area. Just a couple of tours and then sign here. I hadn't expected big questions about my plans or lack thereof. I realized I needed to make some real-life decisions, and fast. It was the middle of summer, and the rent at my apartment had increased again. Orange County is beautiful. It's where my job and school are. It's safe, and most important, it has always been my home, but it's darn expensive. As I contemplated my lease renewal, I punched in some number on my phone's calculator. I realized my new rent was almost the same as a mortgage on a modest condo. I'd received an unexpected inheritance, and perhaps if I saved a little more, less Chipotle, more Del Taco, this would be a chance to get my own place. That night I decided it was time to invest in my future. It was time to take a chance. It was time to go online. I managed to get a handle on home buying sites like Redfin and Zillow. And that week I got to work. I drove all over Orange County from Irvine to Brea, searching for open houses and scheduling tours with a real estate agent. All right, we'll stop there. That will conclude our literary and jury charge practice.